What if someone paid you thousands of dollars, just to not do something? This case answers a huge question in contract law. What actually counts as a valid deal? And surprisingly, the answer isn't about money or benefit, it's about giving something up. This is Harmer versus Sidway, a classic case from New York in 1891. It involves an uncle, William Story, and his nephew, also named William Story. Yes, same name, different generations, and one very unusual promise. In 1869, the uncle made a deal with his teenage nephew. He said, "If you avoid drinking, smoking, swearing, and gambling until you turn 21, I'll pay you $5,000. That's a huge amount of money, especially back then. The nephew agreed, and actually followed through for years. When he turned 21, he told his uncle, "I kept my promise. Pay up." The uncle wrote back, confirming the deal, and said he'd hold the money with interest for safekeeping. Later, the nephew transferred his right to the money to someone else, and eventually, it landed with Harmer. But when the uncle died, his estate refused to pay. So here's the big legal issue. Does giving up a legal right, like drinking or smoking, count as valid consideration for a contract? Even if the person giving it up actually benefits from it? The New York Court of Appeals said yes, and this is where it gets interesting. The court explained that consideration isn't about whether the deal was good or fair. It's about whether someone gave up something they had a legal right to do. The nephew could have drunk, smoked, and gambled. Those were legal choices. But he gave them up, specifically because of the uncle's promise. That sacrifice, called forbearance, was enough to make the promise enforceable. And the court made something very clear: it doesn't matter if the nephew actually benefited from living a healthier life. What matters is that he restricted his freedom in exchange for a promise. So the court ruled in favor of Harmer. The contract was valid, and the estate had to pay the $5,000. Here's the key rule: giving up a legal right, called forbearance, is valid consideration. Even if the person giving it up doesn't suffer harm, or even benefits from it. Courts don't measure whether the deal was worth it, they just care that something of legal value was exchanged. This idea shows up everywhere in modern contracts. Non-compete agreements, settlements, and even everyday deals often involve giving something up. And thanks to this case, we know that giving up a right is just as powerful as giving money. It also reinforces a big principle: people are free to make their own bargains. Here's the bottom line: a contract doesn't need a benefit, it just needs a trade. And sometimes, the most valuable thing you can offer is simply choosing not to act.